You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 54, How to Respond to a Restriction Requirement. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. In the last episodes, I talked about amending parts of your application, usually in response to an office action. In previous episodes, I also talked about responding to different kinds of rejections, such as novelty rejections, obviousness rejections, and these are called the first office actions on the merits. What this means is that it's the first office action where the examiner will write and tell you that you can't get a patent because your invention isn't patentable. But often the first thing you'll get from the patent office, besides the filing receipt, isn't about whether your invention is patentable. It's going to be that your patent application has more than one invention in it. Now, why would your patent application have more than one invention in it? It's actually pretty common. Let's say you came up with a new cure for baldness. You came up with some ointment that has a brand new chemical. You can write claims that cover that new chemical. But you can also write claims for treating baldness that maybe have to do with the steps for how long the ointment must be in your scalp and for how many days. Maybe your chemical can only be made using certain chemical processes, and you write claims having to do with the processes that make your chemical. Because doing patent searches can get really complicated and time-intensive, the patent office doesn't want to place what's called an undue burden on the patent examiner, so that the patent examiner will say that to start with, you need to just pick one of those inventions to start for your examination. Now, the easiest thing to do is not fight the examiner on this. You can fight the examiner and argue that your different claims are really for the same invention, but just really minor variations, and it doesn't cause an undue burden for the examiner to search them. But even if you fight the examiner on the requirement, you still have to pick which single invention covered by specific claims that cover that invention the examiner should examine first, just in case you don't convince the examiner that it's one invention. I'm going to go over an example that what I think is really over the top in terms of multiple inventions. Most of the times, you're not going to have an application that has such different inventions in a single application. If you want to follow along, you can search for U.S. Patent application number 12028349. The title is Jewish Law Compliant Insect Checker and Sabbath Toothbrush. So the first claim for one invention says, the use of a light-emitting device for checking food for insects, wherein the light board is powered by rechargeable batteries within the device. And Claim 6 says, a toothbrush for use on the Jewish Sabbath, comprising a handle and bristles coupled to the handle, the bristles being spaced so that water contacting the bristles is not caught between the bristles. So what does this light device have anything to do with a toothbrush? Absolutely nothing. So when the examiner sees this, he or she is going to say, you need to pick either claims 1 through 5, which have to do with the light device, or claim 6, which has to do with the toothbrush. Now, you might be wondering why Jews need light devices and Sabbath toothbrushes, and that's an entirely different topic. But basically, according to Jewish law, you have to be careful about what you're allowed to eat, and special care must be taken not to eat bugs. So vegetables have to be examined to make sure there aren't small bugs in them. That would be the purpose of the light device for checking insects. For the Sabbath toothbrush, there are certain laws that must be followed on the Sabbath, and one of them has to do with squeezing liquids out of things. So you can see that a normal toothbrush that has a bunch of bristles might pose a problem on the Sabbath because the act of brushing your teeth might cause some liquid to be squeezed out of the toothbrush. Anyway, that's not really the point of this podcast episode, but if you want to know more about Jewish-related inventions, I actually wrote a book called Kosher Patents, where you can find it on Amazon.com, and I wrote one for Christian-related patents called What Would Jesus Patent? That's just a little plug for my books, which aren't really related much to this episode, but I thought I'd include it. So anyways, back to the restriction. If there were no restriction response, the examiner would have to search for light devices and also have to search for toothbrush devices. Yet when you filed your application, you just paid a single fee for filing, searching, and examining. The patent office doesn't want you to pay a single fee and then you actually get a patent for multiple inventions. So you have to pick which invention you want examined first. In this case, let's say by the time the examiner examined this, the inventor gave up on the toothbrush and was just focusing on the light box. So in the response, the inventor would write something like this. The examiner required restriction of the invention to either the light box of claims 1 through 5 or the toothbrush of claim 6. Applicant selects the light box of claims 1 through 5 without traverse. Now, what without traverse means is that you're not going to fight the examiner that all claims should be examined at once. If you wrote with traverse, what you'd be saying is that if you had to pick, you pick claims 1 through 5, but you really think that claim 6 should be examined as well because it wouldn't cause an undue burden, and it's not patently distinct. In this case, you're not going to win if you try to do it with traverse, and in general, it's not worth fighting about restrictions. The standard strategy is to pick the invention that's most commercially viable. So what you do after you decide which claims you want the examiner to examine is you have to designate those by claim identifiers. I talked about claim identifiers in a previous episode. For claims 1 through 5, assuming that you're not going to change anything else about them, you put them in parentheses, and after the claim number, the word original. For claim 6, you don't put canceled, you put in parentheses, withdrawn. And you keep all the words in there, no strike-throughs or deletions. Let's say claims 1 through 5 get allowed. You can ask the examiner to also allow the claims that were withdrawn, but if they're really different, it's not likely going to happen. Well, what will happen is the examiner will cancel those claims at the end that weren't examined, and when the patent issues, it will just have claims 1 through 5. This is where divisional applications come in. I've mentioned divisional applications, and keep saying that I'll get to them in later episodes. What you do at this point is you file a brand new application with just the toothbrush claims that you withdrew. Basically, what you did was you divided the application into the light box invention and the toothbrush invention. Then you will start the whole examination process over again with the toothbrush claims, and if those are patentable, then you'll get a separate patent for the toothbrush. Now you can file a divisional application at any time before your first patent issues. Once it issues, you cannot file a divisional application, and most likely won't be able to file any application at all. So why would someone file an application if they knew that it was going to be divided anyways? What's the point? One of the reasons are filing fees. If you had two inventions, but you didn't know which one you might pursue, you might file a single application with lots of different inventions and pay a single examination filing and search fee, which might be around $800 for a small company. Then a year or two later, when the examiner finally gets to it, at that point you can decide which one you want to pursue. If you want to file a divisional application, at that point you can pay the extra $800, but at least you spread your costs out and you don't have to pay it all at once. The other reason is that it's usually not so cut and dry and whether there's more than one invention. Maybe you came up with an invention for a new kind of motorcycle, and in one version it has 2 wheels and another version has 3 wheels. Now, there are ways to write claims that cover both versions in one set of claims to avoid restriction, but maybe it's in a gray zone on whether the 2 versions are actually 2 different inventions that are distinct and would cause an undue burden, or whether it's just one invention. So don't freak out if you get a restriction requirement. Just look through the claims that you think are most important for your product and pick one of those and then withdraw the other claims. If you still want the other claims, you could file a divisional application, which I'll cover in more detail, probably in 2 episodes, as long as you file the divisional application before your first patent issues. There are all sorts of nuances that I just didn't get to about restriction practice, such as when you might really want to fight the examiner on the restriction requirements and arguments to use and strategies to avoid getting restriction requirements in the first place. But this is just a broad overview on how to simply respond to a restriction requirement by not fighting the examiner, which is usually what you'll want to do. You select the claims, and in the response, put in your listing of claims with status identifiers and withdraw the claims that are not part of your invention that you're selecting. There is a related kind of requirement from the Patent Office called an election of species requirement, which is similar to a restriction requirement, and I'm going to cover that in the next episode. If you want help with your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at EP054-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.